great. Okay, so we kind of see if you can type in the chat box who you see as the other. And so if Grace or one of the organizers who can see, if you did put other on the poll, if you can just type in a little bit of who you are, just to do it for a second.
We're seeing immigration coordinators, licensed therapists. Trying to read.
Great. And so the other kind of question that we have for you is to kind of get a sense a little bit about what is happening on the ground. And so to that end, we want to ask you another question that we're going to put in a poll. Have you noticed an increased reluctance of immigrant survivors in reaching out for help? Okay, so we have people that has said 82%, so let me close the poll. That 74% of you have said yes and 26% of you have said no. Okay.
And Cecilia, we don't see, okay.
And so there's the results if we see them?
Yes.
Okay, great. Okay, now can we see my screen again?
No.
You can't. Okay.
So there are some folks that are saying they can't hear the audio. I'm trying to figure out the best way to let them know.
If they don't have any computer audio, then I'm sorry that we're not going to be able, but we are recording this, and so we will make sure that you get it as we go, but we only need to have some computer audio. So I am sorry for that in terms of the technical. There is no call-in option. Okay. Are we ready to go? Do people see the presentation again?
No.
Okay. Okay, let me just do it again. Okay, so here we go. All right. Now I'm going to put it back to the presentation. Can we see it now?
No.
Oh, Dios mío.
See the poll.
You see the poll. Okay, so let me push the poll. The poll should be closed.
I just took over, Cecilia. Do you guys see the disclaimer up on the screen?
Can you see it now, everybody?
I see the webcast, but not the screen for with the PowerPoints.
All right, just give us a second. We apologize.
No, you know what? I can do it, Alon. It's okay. All right, so here we go from here. We should be good to go.
Yeah, I see it, Cecilia. Does everybody else?
Lovely. Thank you, everyone. So by listening to this webinar, we are going to be able to implement enhance your survivor and family safety plans for immigrant survivors. We're going to talk about some key ways to protect immigrant survivors and engage in some systems advocacy. And we're going to be able to share some materials with you, like Know Your Rights materials, some power of attorney templates, and so to give you the tools that you are going to need to try to address some of your clients' concerns. But before we do that, we're going to start with a little bit of the overview of the executive orders and the DHS memos.
Okay. Hi, everybody. This is Grace. And what I'm going to do is try to do a really short and fast summary of the executive orders issued by the President at the end of January. By no means is this comprehensive because there's a lot of detail and things that are still being worked out. And the other piece I'm going to say is that you know, I'm not going to be giving an overview of immigration law protections that exist, and so I'm going to try to just summarize what the orders say and what that means in terms of existing programs that exist for domestic violence victims and sexual assault victims generally, and then I believe Leslie may talk a little bit more about specific immigration protections for victims. Next slide, please. So, as many of you have read in the news, the President has issued 3 specific immigration-related executive orders. 2 of them were issued on January 25th, one relating to border security, one relating to interior enforcement. And then there was a 3rd one that was issued January 27th that I'll shorthand say travel and refugee ban. That was issued on January 27th that many of you, I'm sure, heard about the immediate impact in the news. So I'm going to talk specifically about some of the implications of these executive orders, and then I'm going to talk about what we know from the memos. There were some implementing memos that were issued about the first 2 executive orders, and try to explain what we know about how the Department of Homeland Security is interpreting those executive orders. Next slide, please. So, as you know, in terms of the particular content relating to the travel ban executive order, individuals in that order, it bans the admission and the processing processing and admission of individuals from 7 majority Muslim countries, and they're listed there: Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. It completely stops refugee processing for 120 days. Oh, excuse me, the 7-country travel ban, that is a 90-day halt for now, and then the refugee processing halt was for 120 days. It limits refugee numbers for this fiscal year to 50,000, and that is reduced from 120,000 individuals. And since we had already admitted almost 50,000 at the end of January, pretty much that means for the rest of the year there wouldn't be any more admissions of refugees for the rest of the year from any country. And then there was a complete ban or bar of Syrian refugees. And so, as you all saw on the news, that had an immediate impact on people that were traveling that had already been approved, had visas in place. It impacted individuals that had already have permanent residence, and individuals that have non-immigrant visas like student visas or work visas that were out of the country traveling. And so what happened was because of the immediate impact that was felt, there have been over 50 lawsuits filed around the country, either on behalf of individuals who were impacted or large classes of people that are impacted, challenging the executive order. And so first there was a national stay of removal out of New York, and then Washington and Minnesota filed a lawsuit on behalf of a large, for people across the country. So as of this particular moment, there's a temporary nationwide restraining order to stop enforcing the sections involving the 90-day travel ban and the 120-day halt and refugee processing, as well as the indefinite Syrian refugee ban. So, as many of you know, there was that immediate temporary restraining order that was appealed to the Ninth Circuit Court of Appeals, and as of February 9th, the Ninth Circuit Court of Appeals upheld that temporary restraining order, And so the question now is what's going to happen, because the Department of Justice has informed the Ninth Circuit that the president is working on issuing a new executive order that amends the prior one. And so we had heard that that was going to be issued this week, but now it was postponed until next week. And so what I'm telling you now about what that executive order does is likely to change by next week. Next slide, please. So I think this particular executive order is the one that we are seeing impacting folks right now in the news. That starting pretty much last week, folks are being impacted, and in ways we are hearing about raids and detentions of several hundred people around the country, and ICE actively engaging in enforcement activity in more overt ways than we've seen for a long time. So what the executive order of January 25th did was it revised the Secure Communities program, and what that means is it involves more active information sharing of people that are detained by the police with ICE. It encourages cooperation between immigration and federal and state law enforcement officials through essentially contracts, and it makes it, this 287G essentially deputizes local law enforcement officials to serve as immigration agents, essentially. I mean, that's the shorthand. Executive order calls for taking away funding from sanctuary jurisdictions, meaning those that are not engaging in particular turning folks over from law enforcement to ICE. It calls for more immigration agents, and it calls for increased fines and penalties for those who are unlawfully present in the country and those who facilitate their presence. And for our purposes, we don't really know what that means. That's going to be a process in which they do some rulemaking or develop more guidance. But obviously that has an impact on the survivors that we that encounter ICE, and potentially those of us, we don't know if that will implicate all of us that help those who are unlawfully present. Next slide. And the big piece that I want folks to pay attention to that has serious implications for victims is changes in enforcement priorities. So these are the new priorities, and some of us like to say it essentially means almost everybody. It includes folks that were already inadmissible or deportable under immigration law, so ones that have been long-standing. Those are going to continue to be priorities. And then the other new priorities include anybody who is unauthorized to be in the country, whether they've overstayed a visa or they entered without authorization, that have potentially pending criminal cases or prior criminal cases, convictions, excuse me. And then the big one is those convicted or charged with any criminal offense, or those that have committed any act that constitutes a chargeable offense. And
so Grace, I have a question about that.
Mm-hmm.
So that just means anything. If it's driving without a license, it's any criminal offense. There's no specificity in terms of the types of criminal offenses they're looking at.
Correct. And the guidance actually doesn't, I'll get to that, but the guidance doesn't actually specify what that means. And it could be local and it could be federal. So, obviously those who may have been working with false documents, potentially, that could be considered fraud. you know, it encompasses a lot of people, and it encompasses folks that, yeah, it could be almost anybody who's, you know, undocumented. Certainly those who already have final orders of removal, that means people that have been ordered deported, and you know, they're not in the course of appealing that case. Those who've committed fraud or misrepresentation in applications to a government agency, and that could be in the context of immigration, it could be in the context of public benefits or housing, etc. Those who've abused a program relating to public benefits, you know, potentially, again, committed fraud. They may not have reported all their income to receive a public benefit, or not, you know, included all their family members, etc., on an application. Potentially, most likely those, you know, that have some kind of finding of fraud. And then the big catch-all is those believed to pose a threat to public safety or national security. And what we've seen already in the detentions that have happened have been, you know, allegations that somebody might, you know, belong to a gang or might have associated with individuals that have, you know, have a gang history, etc. But you know, that particular individual who's been detained doesn't actually have any charges or has never even been, you know, stopped by police, etc. Next slide, please. It also terminates or rescinds all prosecutorial discretion guidance and memos, except in the case of deferred action for childhood arrivals, or DACA. And what that means, specifically from our vantage point, is there was a series of memos that were issued by DHS relating to victims of crime and witnesses, and those with pending U visa and immigration cases, VAWA cases, etc. And so in the past, we've been able to point to guidance saying, you know, you shouldn't detain this person, you shouldn't proceed with removal proceedings, and if they were somehow ended up in removal proceedings, we'd be able to ask for stays or ask that ICE close the case. And so though these particular prior memos relating to victims and witnesses haven't explicitly been rescinded or revoked, the way that the guidance relating to this executive order is drafted seems to imply that you know, all of these cases involving victims and witnesses have to be resolved on a case-by-case basis. What, you know, we perceive is that those who appear to be most at risk for enforcement are those that have the prior, you know, those that are actually in jail or in detention right now, and you know, ICE appears to be regularly visiting or checking the lists of those, you know, through the criminal background checks that are in detention or jail. Those, again, with criminal history or potential criminal charges. And then people who have been ordered deported in the past and have lost or forfeited any appeals. So on this particular last one, for example, you know, there have been people that were not eligible for any kind of immigration relief, and they had been ordered deported in the past, and because of prior prosecutorial discretion memos from the prior administration, one of the, you know, discretion memos talked about parents of children who were U.S. citizens or permanent residents, and so that was, you know, one of those areas where the previous administration didn't exercise, you know, in exercising their prosecutorial discretion, decided not to go ahead and remove folks. And so I'm sure many of you have seen in the news that is no longer the case, that folks who have been ordered deported in the past have been taken into custody, and folks are already being deported in this context. And so you know, we're hearing, you know, starting to hear in the news now about people deciding not to go into their check-in appointments, et cetera, because of the likelihood that they will actually execute those prior deportation orders. Can you, next slide, please? One of the other provisions in the memo that we are extremely concerned about and that we will be advocating and continuing to talk with internally with the administration as well as with other policymakers is language that eliminates Privacy Act protections that for anybody who's not a U.S. citizen or permanent resident. Right now, the Privacy Act protects personal identifying information in records held by DHS about, you know, everybody, all, you know, immigrants, whether they're non-immigrants or people applying, even if they're not permanent residents yet. And so what DHS has to do is put together a comment period, and we'll be seeking public input on this piece. But for those of us who work with victims, you know, that don't have specific protections under the Violence Against Women Act, for example, people that might have non-immigrant visas or people that are you know, married to a permanent resident who are applying for status but not yet covered under VAWA, you know, we are concerned about their personal identifying information not being protected. And so,
and Grace, I'm sorry to interrupt you, but I think that I just want to let people know that this is the Privacy Act that is different from VAWA Confidentiality. And so, and Leslie's going to talk about that in a moment. So we do recognize that there are some questions coming in, and our speakers are going to try to address them as best they can in the course of the presentation, but just realize with the size of this audience, we might not be able to get to us, but we'll definitely let you know how to follow up. Sorry to interrupt you, Grace. Go ahead.
Okay. Yeah, I was just going to say that, but anyway.
Sorry. Cut you off at the pass.
Right. Okay. Going on to the next piece, the memo also talks about establishing a victim of immigration crime engagement voice office at DHS within ICE, and what that office will be set up for is to be a liaison between ICE and victims of crimes that were committed by removable aliens, and reallocating resources that are currently used to advocate on behalf of quote-unquote illegal aliens to the new office. And so we're not quite sure what that means. We do believe, you know, there was an advocate, a particular advocate who within ICE that you know, served as a voice to just raise issues of concern in development of policy, and we believe that may be what they're referring to in this context, or potentially might refer to programs that have been funded by DHS to provide you know, information for folks in detention. We're not sure what this means, but we will be following up and trying to figure that out. And for those of us who are you know, working in the victim advocacy field, trying to make sure that folks are linked up to resources, you know, if they need you know, not, you know, resources that are not immigration specific. So next slide, please. Okay, so there was another memo that was issued on the 25th of January that talks about border enforcement, and then there was also an implementing memo that went out just this last week as well. And so these are some of the elements. There's, you know, the call for the U.S. border, U.S.-Mexico border wall, and that we just saw an announcement go out relating to requests for proposal about that. It does talk about detention of all those intercepted at the border while their cases are pending. And it makes it so that there's mandatory detention as the default for all immigrants that are suspected of an immigration violation. And so what this means is they are supposed to be detained until they're removed from the United States, or unless they're required to be released by law or some kind of settle agreement or court order. until they have valid immigration status. Or there's, supposed to be detained until they're found to have a credible fear of persecution by an asylum officer or immigration judge, or until they're specifically paroled into the United States. And I'll talk about that more in a second. Also, what it does is expands expedited removal. And so what that means is that for those who appear to have entered without authorization, if they've been in the country for less than 2 years, anywhere in the U.S., they are subject to expedited removal. And so what that means is that folks can be removed in as little as 24 hours without the opportunity to appear before an immigration judge or have a chance to speak to an attorney. So right now, expedited removal applies to those who are within 100 miles of the border and they've been in the U.S. less than 14 days, or those who arrive by sea other than at a port of entry. And so what this means is that expedited removal is expanding to anywhere in the country, and people will need to show that they've been in the country for they've been in the country for 2 years. And this process will require publication in the Federal Register for regulations, but before they implement that, but just know that that is likely coming. There's also in this executive order and implementing memo, it instructs the Department of Homeland Security to return non-citizens arriving on land from either Mexico or Canada to the territory from which they arrived, pending formal proceedings. So it instructs that people be detained until removal proceedings can happen, and facilities be made for people to appear via video teleconference. Although the memo doesn't explain how the United States would maintain detention centers in Mexico or Canada, so it's not clear how that's going to happen. It also directs expansion of resources to, increase detention facilities at the border. And this next one, it severely limits the use of parole, meaning that rather than expanding, so right now we have classes or groups of people where the Department of Homeland Security will admit them for humanitarian reasons, and so up to now we've had, in the context of the Violence Against Women Act, groups of people that we've been working with them on just granting folks parole. For example, if those folks are on the waiting list for a U visa, or they're coming to join their family members on VAWA that have VAWA status, and so will be, that will be curtailed. Also, in relation to unaccompanied minors, they're talking about following up with kids who were previously designated as unaccompanied children to figure out whether they've got parents in the United States or not, and if they don't have, they're no longer considered unaccompanied children, they will more likely have to go through the removal process more quickly, and so more likely there will be children subject to removal. And then there'll be more emphasis on law enforcement and state 287G agreements, as I mentioned before, and more Border Patrol agents. Okay, next slide, please. So I just want to highlight, I'm not going to go into detail about all of this, but there have been some leaked executive orders that are floating out in the ether, and one that we've heard a lot about that people are concerned about is that of greatly expanding the application of public charge, meaning people being ineligible for status or removable for becoming dependent on government benefits. What we do want to say about this to assure people, first of all, is that it doesn't apply to U.S. citizens. So people benefits for their kids that are U.S. citizens, public charge would not apply to them. And second of all, those with status under the Violence Against Women Act are exempt from public charge. So just to provide that piece of context, but we are anticipating something possibly being released, and we don't know what it's going to say yet. So we will surely, keep folks updated as we learn more. But I wanted to flag that because we're getting a lot of questions about it. There are some other leaked memos that talk about some of the worker and non-immigrant visa programs, as well as, there's one being leaked about ending the DACA program. That, we don't know what's going to happen. We are just waiting to see what happens with that, and we will keep folks updated. So why don't we go on to Leslie so that she can start talking about confidentiality and screening. Thanks.
Great. Thanks, Grace. Next slide, please. So my name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project. I've been trying to type things in the box as we've been going along, and we'll make as many materials available after this as we can. I'm going to start, though, by talking about some quick things on safety planning and confidentiality. And one of the things that I think it's really important to emphasize in whatever happens as we go forward, that now, in light of the memos and things that Grace has discussed and whatever changes there might be in the future, is more important than ever for all of you that are advocates and attorneys and working in any capacity with immigrant survivors to recognize the full range of forms of immigration relief that victims qualify for, and understand which victims qualify for which kinds of relief and which kinds of relief receive VAWA confidentiality protections. It's also super important to document the history of the abuse well, so that people are filing strong cases and the best possible cases, and to know, and one of the key differences between the forms of immigration relief is we've heard recently, and USCIS is seeing this as well, is there's been an uptick in the number of people who appear to qualify for VAWA self-petitioning that are filing U visas, which makes a greater backlog, longer wait, and place people more at risk. So it's really important to understand the differences. And that to screen victims and file the immigration case as soon as possible. Once the immigration case is filed, if it's a VAWA U visa case or a work authorization for an abused spouse of an A, E3, H, or G visa holder, those cases are entered into a computer system at DHS that allow ICE and CBP officers and USCIS officers to see that that case has been red flagged VAWA confidentiality, which means that with good advocacy, there's a better chance of deferring any kind of enforcement action against your client, depending on what their particular criminal history or how many times they've left the United States or whether they have an open deportation case. Those cases are going to be more complex. But it's important to file early, to get it into that system, and to make sure that when you file, there's sufficient evidence so that in a VAWA self-petition case, for example, the victim will get a prima facie determination. Because that prima facie determination is a piece of paper that the victim potentially, you have to talk about safety issues, about carrying it on her, but from an immigration enforcement perspective, having some kind of documentation to show that she's got a pending case that is one of these protected cases could be helpful in good advocacy to stave off some kind of a immigration, an effort to detain her or deport her or from DHS. Because what we do know is that once victims file cases, perpetrators in the 25 or 30% range are calling to turn them in to try to get them deported. And so with increased enforcement, as we've seen historically when there's been increased enforcement, there's greater risk that they may succeed. So having a case on file could be very helpful. So you want to think in terms of your safety planning about that. Next slide, please. So I'm not going to go into all of these forms of relief. I show you this slide to show you the difference between the groups in red, VAWA self-petitioners, cancellations, ascension, battered spouse waivers, U visas, T visa applicants, not continued presence, and abused spouse visa holders. They all get VAWA confidentiality protection. DACA, SIJS, and asylum do not. Next slide, please. And, oops, did you take the infographic out, Cecilia? Oh, thank you. So in, I think it was December, DHS published this infographic that is really a great tool that I encourage you all to get and use. We have a Spanish language version that we worked with a group in Mexico to translate that'll be up on our website probably today or Monday. And it's a live infographic, so if you click on any of these boxes, it takes you to all the information and brochures that DHS has written on that particular topic. We also have a web page where we've gathered all those informations and links if you want them, but it's a good tool as a way to screen and sort between these types of relief that we encourage you to use and distribute widely. We're distributing it to police and courts and other people who might be good people to get the word out to victims who may not have found their way to our programs yet. Next slide, please. So I'm going to turn the rest of my time today to talking about VAWA confidentiality. And when you talk about VAWA confidentiality, it's important to understand that there's 3 different types of protection that come with this law. Violation of any of the 3 prongs of VAWA confidentiality is each instance of violation could result in a $5,000 fine for the individual officer who violates and or disciplinary action. We published today a document where you can actually see each part of the VAWA confidentiality statute, everything anybody at DHS that's public, that we've been able to get publicly has said about it, and all of the legislative history. So it's a really good tool to understand from what DHS says the protections are, which are basically what I'm going to be telling you today. But sometimes for courts and other people you work with, it might be useful to show them the DHS versions of this.
And Leslie, is that something that we can put on the Dropbox as well?
Yes, I just put it up on my website. I'll email it to you by the end of the day.
Great.
It's just we're still site checking as I'm speaking literally.
No, that's great. Thank you.
No problem. So there are 3 types of protection. Non-disclosure, which means that generally covers victims who filed one of those red-colored cases, a VAWA confidentiality protected case. The other 2, the abuser-provided information, reliance on abuser-provided information prohibition, and the locational, the places where they're not supposed to be generally doing immigration enforcement, those generally apply without regard to whether or not a case is filed, but those operate better to protect your client if you filed the case and your client's file is in the red flag system. And the reason it does is there are electronic fingerprints on that file. If an immigration officer looked at her case at all and checked or didn't check the screen they were supposed to check, and in terms of enforcement, it really helps. And I think every time there's a tick up in immigration enforcement, having a case on file and using the internal system and making it work is going to be more effective to protect your clients. So the other thing that I wanted to mention is the abuser-provided information piece. It protects all victims who are abused by a spouse or parent without regard to whether it's a VAWA or a U or what kind of case or if there is a case. For cases of people who are in the process of applying for T's and U's, it covers them as well. And in the process of applying has been interpreted by USCIS to mean they're preparing their application. It doesn't have to be filed yet. Again, you'd need good advocacy.
Leslie, I'm sorry.
Yes.
Can I just ask you a question about that? Especially, I think, in the first prong, when we're talking about all victims abused by a spouse or parent, how would that kind of come into play in terms of invoking those confidentiality provisions?
So what happens is, what I've done and what other people I know have done is, let's say the issue is again, depending on who the officer is, she can say she's a victim. That might be enough. but I don't know nowadays. We don't know what's going to happen going forward. And even in the past, that wasn't the best way. Copy of a protection order, a receipt notice or a prima facie determination in a VAWA case, some kind of, you know, a letter, you know, a note from, you know, if you've got a U visa case, the cert, something like that, but basically, or, you know, something that's saying she's a DV victim. And you have to, they have to accept any credible evidence, and there's some really, really good language in the policies that we should be raising up and using to get, you know, to do advocacy with them. But it's going to take good advocacy, but I believe the material to do it is there in the paper I was telling you about a little bit ago. In terms of the locational prohibitions, what's supposed to happen is there's no active action supposed to be taken at protected locations, or the notice to appear must state how they complied with VAWA confidentiality. So if they ended up at a courthouse based on a tip from a perpetrator, they're going to have to show that their getting there wasn't fruit of the poisonous tree, or that they, you know, that they verified that there were removal orders or criminal convictions or something else that they were able to independently verify. This is an area that is not at all clear. This is an area where you have something happening. There's at the Office of Civil Rights and Civil Liberties, I have the complaint form on the materials that you have for the website, for the webinar, and we can mentor you through, and I actually have materials step-by-step on how to prepare to file a complaint. Because those kinds of details about what's going to be enough and how much background did they do enough and did they make a mistake or not about what they're supposed to do, that's very much going to need a CRCL investigation to really dig into and figure out.
And next CRCL is what? Did you mention that, Leslie?
Yeah, Civil Rights and Civil Liberties Division of the Department of Homeland Security that is responsible for these investigations.
Great, thank you.
Okay, locational, next slide, please. Okay, the locations that are protected, so I told you a little bit about it. These are the locations that are protected. So it's basically places where victims would go generally to receive victim services. In terms of community-based organizations, they use the VAWA definition of community-based organizations. So it's generally programs serving survivors. And that the site for that is in the publication I'm putting up this afternoon. And that courthouses, it's not a general ban on courthouses, it's courthouses in connection with a protection order, custody case, civil or criminal case involving a domestic violence, sexual assault, human trafficking, stalking, those kinds of criminal activities. Next slide, please.
Right, and these are the protections, and if you're looking for the legal site to that, I believe it's INA, the Immigration and Nationalities Act, Section 239E.
239E.
Mm-hmm. Great.
So, relying on perpetrator-provided information includes abusers, perpetrators, and traffickers. The government cannot gather or use information provided solely by an abuser, trafficker, perpetrator, or a closely associated person to that. Family members have been defined in the policies. They've talked about other relatives. Some places talk about family members living in the household. It's that and all. And that closely associated could mean other things as well, although DHS doesn't have anything in writing on that other than this terminology. To take an adverse action means arrest for civil immigration violations, placing somebody in removal proceedings, placing somebody in detention, seeking from the perpetrator or using information provided by the perpetrator as part of an adjudication of a victim's immigration case. Next slide, please. So, and that it prohibits, the other issue that people often don't understand is that when you're talking about the information protection, so let's say she files her VAWA, her T, her U, her family-based visa work authorization from, we have to come up with a short name for this, for people married to visa holders. It protects information that DHS and DHS, any Department of State, the Department of Justice, and DHS are barred from disclosing, as are, according to the U visa regulations, and other policies at DHS, anybody who receives the information from DHS under any of the exceptions, from disclosing information about the existence of the case, actions taken in the case, information case, or any information contained in the case file. Disclosure is prohibited to all persons, not just the perpetrator, and the protections apply forever, from the time of filing forever, unless the case is denied on its merits and their time for appeal is, all the appeals and their times for appeal has been exhausted. Next slide, please. Okay.
I think we have this from before.
Got a cheat sheet on this.
Where it applies to. And we talked about the exceptions.
Okay, what do you, pardon?
I think this is the slide that you had mentioned before when you put up that chart.
No. Okay. So this, let me explain what we're talking about. So who does VAWA confidentiality protect? It protects VAWA self-petitioners, and that includes, the legal definition of VAWA self-petitioners includes battered spouse waiver applicants, VAWA self-petitioners, VAWA Cuban, VAWA Haitians, and VAWA Nicaragua NICARA applicants, VAWA cancellation and suspension, U visas, T visas, and then the work authorization spouses. Okay, next slide. So I think this is my last one. The exceptions to disclosure are the following. They are to law enforcement, national security, and for judicial review. When in the law enforcement and national security is solely when it's for a legitimate law enforcement or national security purpose, and in a manner that continues to protect the confidentiality of such information. So it's not random discovery in every criminal case, and in fact, many criminal case discovery requests have been denied. It's not random discovery in every family court case, and all family court cases, virtually in every case that's been reported, has been denied, and we have case law on that, and that's a whole other webinar if you want it. We have it online, and we may repeat it again sometime in the future. And then the judicial review provision is limited by case law and to judicial review of an immigration case filed by the victim. It's not every random court. There are exceptions for public benefits to public benefits granting agencies for public benefits purposes, and adult victims. If all adult victims in the case waive confidentiality, then confidentiality can be waived. Children can't waive confidentiality, and then there's some release of information for data collection and congressional oversight, as long as there's no personally identifying information.
Leslie, I have a question for you before we move on, and I think mostly this comes from looking at what Grace had mentioned in terms of what the enforcement priorities are, and looking at kind of the wide range of criminal activity that could be considered under the enforcement priorities, and how you see that intercepting with the exception to VAWA confidentiality for law enforcement purposes.
I would think, I mean, first of all, as you can, from Grace's presentation, everything we can do to have criminal records be disappeared, like reopened and dismissed, and anything we can do for victims in that case would be useful no matter what. If you have a victim that has a criminal record or has a, outstanding removal orders and things like that, I think it's my understanding is that what VAWA it should tell them it's a VAWA confidentiality protected case. There's language in existing policies. Now let me say something about the VAWA confidentiality policies. The VAWA confidentiality policies were not discretionary, that the government, in fact, they've been issued in the Bush administration, the Obama administration, they've been issued all over, and in the Clinton before that. They were mandated by statute to have policies. So getting rid of them is not as easy as other kinds of policies. They're likely to potentially survive, and this is an area that has had huge bipartisan support, as you'll see from the legislative history. So as to this issue, I think what I would say is you're going to need exceptionally good advocacy, and you may be able to get ICE to exercise their discretion not to initiate, not to continue removal actions against your client, or if they issue an NTA, not to detain her, there are some things you may be able to do. There's no real solid clad answers, but having VAWA confidentiality protection, it means that they can exercise their discretion not to, and especially if you can show that there was a connection between the, let's say, the criminal conviction that she has and the abuse.
Right, and I think that nexus piece is key. And I think basically, I think what a lot of people are concerned about and what we hear is that under these new implementing memos and this guidance that ICE might try to drive a truck through that first exception. And so I think it's important to kind of do all that preparation in terms of seeing what you can do to some post-conviction relief for the survivor. I think that nexus component is so critical, and I also think that it's a monitoring issue that we need to kind of keep ourselves informed how this is playing out on the ground.
Right, and the rest of my answer on this, Cecilia, is that this is something where, to the immigration lawyers on the call and to the victim advocates, what I'd say is that having really good relationships between immigration folks doing the cases and the victim advocacy community is super, super important here, because what we've seen is that victim advocates work with the victims for a longer period of time than those of us that are attorneys do. And they're in a better position to be able to help get the information or help people feel comfortable revealing that they might have a criminal history, they might have been arrested before. You might find out sooner if you're working closely with your advocates on the cases.
Thank you so much, Leslie.
You're welcome.
So now we're going to get to the heart of the matter and talk about enhancing your safety plans. And in the Dropbox or in your control panel, you can raise your virtual hands in terms of how many of you actually work on safety plans with survivors now. And then as you do that, we're going to move on, and Grace is going to kind of walk us through a little bit about thinking about safety planning, thinking about the work that many of you already do, and laying that extra layer of immigration issues on top of it. So I'm going to turn it to Grace before Archie and I kind of cover the material.
Hello, everybody, again. So what I want to do for those of you I know are figuring out, what do I tell survivors? What, should they go to the courthouse? Should they get a protection order? Should they call the police? We have, since these orders have come out, and obviously since the news broke last week about the case in El Paso, I think all of us have been getting numerous calls about this very question. And, I think that it's not an easy answer. None of those are easy. There's simple solutions to those questions. So what I want to do is just, help all of you think through how do we actually do safety planning for survivors who are undocumented, or even those who are documented and still fear that they may be at risk of removal, or for their family members, etc. So I just want to, for those of you who are regularly working with victims of domestic violence in particular, but I think some of these concepts transfer to sexual assault and stalking and other other crimes too, is if you haven't had the pleasure or the benefit of reading Jill Davies' Advocacy for Battered Women. It's an amazing and really helpful tool to think about how you actually do safety planning that's relevant for victims, and her model is a useful one to use in this context as well. So you think about the risks that are posed by the actual abuser or perpetrator, and the harm that they cause, the actual injury, the fear, all of those kinds of things. And then in the context of working with survivors, you also think about larger external system-related risks that may face an individual victim. And in order to do good safety planning, and obviously planning, it's changing all the time. It's thinking through the risks that life poses and various systems pose. We have to have information about all of those things to be able to help folks through, keeping themselves safe, for trying to keep themselves safe. So, obviously we, in this, in the work that we've done since, even before VAWA in the last 30 years, have thought through trying to create systems that help, deal with the risks that abusers and perpetrators pose. And what we've come up with involve, we have law enforcement response now. We have, in some places, mandatory arrest. We have criminal penalties for abusers and perpetrators. We have protection orders. We have custody orders, all those kinds of things in the civil legal system. There's victim services, potentially shelter, rape crisis centers, etc. Financial resources like public benefits or cash assistance, housing. I forgot to put medical, obviously, for people's injuries. But, so we think about, those particular remedies to help with the abuser-generated risks, the perpetrator-generated risk. And obviously, one that survivors face is threats of turning people over to ICE or deportation in the context of immigrant survivors. And so, as we're helping folks think through, are those good options for these individuals, we now have the additional system overlay of the risk that immigration enforcement has in their particular situations. And so, like I said earlier, it's really hard without knowing a lot more about what's happening in your own individual community to do safety planning with survivors if you don't know what's happening in your community about these issues. And so what I encourage all of you to do is, if you're not already working with advocates from the immigrant community or immigration attorneys, to make sure that you connect with those folks so that you do have a sense of what's happening in the community on some of these issues. Now, so obviously we want to think about whether or not now this person that we're working with is an enforcement priority. Do they have, beyond being undocumented, because that's a risk for lots of folks, but even folks who aren't undocumented, might they fall into one of the enforcement categories? And so if they do have a conviction, first of all, that's obviously that's going to be first, or they've got a pending criminal case right now, that's potentially going to elevate their risk. And so what does that mean? You want to find out then, if they do have some kind of criminal history, what is your locality's practice around information sharing with ICE? Some of us are in communities where our communities are, quote unquote, welcoming cities or welcoming counties or, welcoming states even. So you want to find out what is happening in your community about that, and, to be able to help individual survivors think through, if I call the police, how much are they working with ICE? Is that a higher level of risk? You also obviously want to think about whether they might be eligible for some kind of immigration law protection, and that Leslie had mentioned a little bit about before. And certainly all of us on the webinar now, and many of you in the participating in the webinar provide training on various protections for immigrant victims. Then there's the question of whether somebody might possibly be considered a public charge, and while that's not immediately of concern for those that at least under the executive orders, that is potentially an issue that folks may be running into in the future. And as we learn more about what the administration intends to do around this issue, we will keep folks updated on it. But traditionally in the past, in-kind benefits and things like housing and food have not traditionally been things that are benefits that would make somebody likely to be considered a public charge. So we don't know what's going to happen in the future with that. And then, obviously the question of course, is whether or not there is increased ICE or Border Patrol presence in your community. Obviously, we know that, there's unfortunately now even an app out there that, people are uploading to their phones to talk about whether there are, checkpoints or raids, etc. So, in terms of specifically giving anybody an answer in their particular situation, there's a lot of information that as an advocate, folks are going to have to find out about what's happening in the community, and it involves just being in touch.
Right, exactly. Keeping your ears and eyes open. So in the interest of time, and hopefully maybe our speakers can stay a little bit overboard to make sure we get it all in. But Archie, I want to kind of turn it over to you to kind of do some know your rights and safety planning. And again, we're not going to know everything we need to know in a webinar, but we want to give you an overview of some of these basic know your rights materials, all of which are in your Dropbox, and then we can take it from there and move into some systems planning as well, or systems advocacy. So thank you, Archie.
Thanks, Cecilia. Sure, no problem. Thanks, Cecilia. And I've been trying to answer questions that were coming up in the question box as well as Grace and Cecilia and Leslie were talking. I noticed a lot of questions with some confusion around who this all applies to and what the orders really mean, and what some of the memos mean as well. And I want to be sure to point folks to there are a number of immigration organizations that have done some summaries and analysis you can read as well. And I want to be sure folks know in the Dropbox I have put 2 documents that Tahari created that are kind of that sort of summarize exactly how these orders might impact survivors, just for some additional reading material. But of course, it's a constantly changing landscape. So getting into briefly the Know Your Rights presentation materials, and again, a lot of this is in the Dropbox. I do think it's important for folks to understand that when our clients, survivors, immigrants, undocumented folks, are being stopped on the street in public places, or detained while they're walking from one place to another. They might be stopped or detained. In addition, it could happen at their home. So we've heard a lot near Tahari service providing offices that there are raids going on, that people knock on the doors. You hear policia, you don't really know what's happening on the other side of the door. And so I'm just going to run through very briefly what our rights are as when we are an immigrant and we want to protect ourselves. Number one is, if you're in a public place, it is okay to say, I don't want to answer your questions. I don't think most people know that. You can also say, am I free to go? Because if they don't have a reason to hold you and ask you questions, they really shouldn't be doing that, and so you can walk away. And so, their Immigrant Defense Project, the ACLU, a number of organizations have put out sort of fact sheets and training guides and different things that you can use to give you more information there on exactly what you can say if an ICE officer or CBP officer should approach you and say, can I see your papers, right? I think it's also important to know that there was this memo signed in 2011 called the Sensitive Locations Memo. It really protects people from being raided or picked up at places like schools, colleges and universities, hospitals, churches, the site of a funeral or wedding, or a march, rally, or parade. And that memo is still in effect at this time. Although we are aware that these, when leaving one of these places or going to one of these places, people are still, eligible to be asked questions about their immigration status and possibly arrested. Separately, I want to add that it is important not to run away, that it's important not to lie, and that it is important to stay calm, because ICE officers are paying very close attention to, how you're behaving, not just whether you have papers or not. And so as we work with our clients, as we are talking to, as advocates, we're talking to our communities, it is important to share some of this information. If we are detained, we can say that we would like to exercise our right to remain silent. People think of that when being arrested by the police. It's the same with immigration. And so if an ICE officer were to approach a client and say, you're being detained, put handcuffs on, the person can say, I would like to speak to an attorney. You can refuse consent to a search, and I'm going to get into that in a moment when we get to home as well. But you can refuse to sign documents until you've spoken with a lawyer. You do not have a right to lie. I think that's important to note, or to show false documents or resist arrest. Again, not lying, not running away, and staying calm. Very important. Let's move on to the next slide, please. What should clients carry with them? I think it's important for all of us who have clients who are in legal proceedings with a lawyer to be sure that our clients are carrying a letter, carrying the contact information of the attorney or legal representative. We're advising as well that clients carry letters saying that the person is represented, because having the business card of a lawyer won't necessarily convince an officer that you're represented. So possibly having something so that if an ICE officer is talking to your client, whether or not your client is English fluent, perhaps your client could show a letter that says, you know, this person is represented by X agency or attorney, and therefore the officer might think twice about doing something without the permission of the lawyer or the input of the lawyer. These red cards, you see the back and front of one on your slide, is a Know Your Rights card that is worth having. We have them at our front desks in our offices. We ask all of our, when clients come to see us, we like to give them out. They have English and Spanish kind of these rights laid out so that somebody could just show this to an officer if speaking up in English and to an armed officer is challenging, as it would be for me. Certainly this card could be useful.
Right.
If one has
Dropbox as well, in terms of ILRC and some other ACLU, all have these cards available.
That's wonderful. Yeah, absolutely. And again, to carry things that are not false, because that false document could be the reason for being for getting in trouble and putting oneself into more jeopardy than if one were simply honest and not lying. Okay, let's go to the next slide. Additional Know Your Rights information for someone who has a knock at the door. And this is, again, I said earlier, happening a lot. There's some confusion right now as to what somebody can or can't do when a knock at the door comes. So if there's a knock at the door and you say, who is it? Often you'll hear police. Now, my mind goes immediately to my local police. They might be telling me about an accident. They might be telling me that I'm not safe somehow. I want to trust that, and I want to open my door. But the important thing to know is that Immigration Customs Enforcement officers also say police, even though they are not local law enforcement and they cannot protect us from crime. And so what we need to remember as we're talking with individuals who are in their homes and could be in jeopardy of going through a raid or something like that is that if they hear a knock at the door, they really should ask, who is it? And if they hear police, they should ask, what kind of police? Who are you with? Where are you from? Are you immigration or are you my local police person? You can ask that. And they have to be honest with you. They cannot lie. And so if you find out that it is an immigration police person, and it's somebody from ICE or immigration police, then we want to find out why they're there, without opening the door if possible. So saying, why are you here is important because, on the one hand, if they're there for a specific person, the requirements upon them are different than if they are there to enter the home and search it. So if they are there for a specific person, they actually do not need a judge's order to arrest somebody. They should have some kind of a warrant. They should have an ICE warrant saying that they are there to pick up a particular person. I've heard anecdotally about ICE officers coming to people's homes, knocking on the door. The warrants have names on them that do not apply to anybody that's in the home, but they kind of flash it and then they get the door opened, and then ICE comes in the home and starts asking people for documents and picking them up. And so what we want to be sure we're doing is that if we hear the knock on the door, we ask if it's police, we find out if it's immigration, we say, are you here for a person or to search the home? And if we find out it's for a particular person, we want to see the name of the person on the warrant. If that person is in the home who's on the warrant, the best advice we can give in terms of following one's rights is to exit the home. Because if the person stays in the home, they're technically evading. And if the person stays in the home and ICE is granted permission to enter the home to take that person, then ICE will likely begin asking about other people in the home. Even though they don't have a warrant. And the way ICE justifies this, as we know, is because they could themselves be under threat, right? If there are armed people in the home, they might themselves be physically in danger. So they do have to ask who else is in the home. And in doing that, then this can become a much more broad and difficult raid type situation. If the person whose name is on the warrant is in the home, that person can leave the home and speak with the officer outside. Again, this would be a moment to ask about being detained, about right to remain silent, about wanting to speak to an attorney. All that could still happen, but should happen outside the home. If the officer wants to enter the home, there should be a valid search warrant from a judge. And this cannot be provided by ICE. And this is a very common problem where ICE will say we have a warrant, but it's a warrant for a person. The individual opens the door and lets ICE in. So this is a really important one to share with your clients, with your communities, as we do with ours. If an ICE officer enters the home because there is a judge-signed warrant, then we have to simply cooperate. We cannot lie. We cannot hide people in closets. Unfortunately, and I learned this in a meeting yesterday, ICE officers are armed, and they are, like I said, they do feel in threat. And so if there are children in closets or other situations like that, which I know is very common, ICE is waiting for somebody to pounce on them, and they will take an approach of protecting themselves, as you can imagine makes sense. So the most important thing would be to cooperate where there is a legal and valid right for them to either take a person out of the home or to enter the home to search. If they are asking for a household member who's not there, then ask the officer to leave contact information. You do not have to tell them where the person is. You do not have to let them in the house, but of course we should not lie. So we can go to the next slide. Okay. Now, if they're inside, again, I just covered this, but we do need to tell ICE if there are people in the home. We do want them to step outside. We want individuals inside to step outside. An administrative warrant is not, meaning an ICE warrant, is not enough to enter the home. If they came in without permission, important to say you do not consent, please leave, and to continually say that if something is going on that you have not agreed to. And it's also important to be communicative about what your medical issues are or childcare, and I know that we'll talk about that more in safety planning. But that, it is important to communicate with ICE, not necessarily status and things. If we're going to say, I don't want to answer your questions until I have my lawyer, a client could still say, but I do have a child I need to arrange childcare for, I'm diabetic, etc. One thing that's also important to know is that there are organizations, specifically I'm thinking of the Immigrant Defense Project, that is collecting information about how these raids or home entries are progressing. Also, I'm sure the ACLU is interested. Any of us who are providing this webinar also would be interested to know and could assist with further reporting. If you have clients who feel that their rights have been abridged because a warrant was provided that was not authorized and ICE came into the home or something like that, we do especially want to know about it so that we can assist in making sure that these kinds of activities by ICE are reported up the chain. ICE believes that they are acting in complete compliance with the law and that they are watching everybody's rights. But of course, what we are told at headquarters may be very different from what is happening on the ground, and so we definitely need to know if there are fact situations that do not comport with what ICE is telling us at headquarters.
Right. Thank you.
On the next slide, we'll talk.
Oh,
sure.
Go ahead.
I'm sorry. There's just one more slide that's mine, and then I was going to pass it back to you.
Great.
Thanks. It's short because I talked about it. But what to do if detained, the main thing here is asking to speak to an attorney and do not incriminate yourself, which means do not say, these are all the things I've done wrong. Again, we're not lying, but we're withholding until we've talked to a lawyer and not signing anything. So if you live with, if you have clients who perhaps have no criminal convictions, have their applications pending, and are doing just fine. They have a couple U.S. citizen kids in the house, but then they have an uncle in the house who's undocumented, and maybe the uncle has an old violation or conviction, or maybe just has nothing, but is just an undocumented uncle living in the house. We want to be sure that everybody in the home is aware that a raid could happen, and that there should be a plan in place to accommodate and care for all members of the family after a traumatic incident like an ICE officer knocking on the door and possibly entering and taking away a family member. That can cause trauma on the whole family. We want to be sure that there's a plan in place and that we are triaging and assisting and helping afterwards the best we can. All right, Cecilia, I'll pass it back to you for safety planning.
Thank you. And I think that right now I'm just going to do a time check. I realize that we only have about 10 minutes left from the presentation time, but I think making an executive decision that I think we want to make sure that we get through these slides and give you this information as much as possible, and for the fact that we are recording it. So if folks would be able to kind of stay maybe 10 minutes in addition so we can make sure you get all the information that you need. And if not, and you need to drop off, that's totally fine. That we will send you the recording of the entire webinar so you can pick up what you missed in those last few minutes. So I just want to kind of make sure that we can kind of do that time check, honor where we are, but that we're going to go through it and make sure that we can kind of give you the information. So I apologize if that causes any inconvenience. So we're going to talk about safety planning and how to build on some of the things that you already do. And in your materials, you do have the IRLC Family Preparedness Guide, and you also have some materials from Clinic, which are available both in Spanish and in English, and that have samples of emergency contact sheets. Kind of what is the information that is going to be important if there is some kind of immigration enforcement action, if there's an arrest or detention. And that includes members of the family who are in the United States, members of the family who are in the home country, medical information, information about finances in schools and who's the emergency contact in your child's school. And encourage your clients to kind of get their documents together. Identity documents to safeguard, including passports for children, medical information, including your insurance, financial information in terms of if something happens, can someone access your bank account? Someone pick up your paycheck? And kind of getting all that information for whatever is going to be needed for that financial component of the safety planning. Immigration papers. And that could be anything. If, for example, you had a matter in immigration court before, what those documents look like. If someone had filed an immigration case for you previously, do you have copies of those applications and of those documents? It's going to be really important to know if something does happen, kind of what the history of it is. And so safeguarding that information, keeping it in a safe place is going to be very important. If your client has a criminal history, to keep those documents together, because that's going to be often key when you're doing your advocacy or determining eligibility of relief. Physical presence documents, proof that your clients have been in the country for a certain amount of time. And this could be important, particularly if you're kind of considering certain forms of relief that might be available to you in which showing physical presence is going to be needed. For example, 9LPR 10-year cancellation, VAWA cancellation, all of those have a component of physical presence. So just proof of pay stubs or bills to prove the physical presence in the United States. And if a client has had prior interactions with ICE or with the Immigration Service, that they memorize or safeguard their alien registration number or their A number. And you're hearing a lot lately about kind of family safety planning, because I think a fear for a lot of survivors is what happens if the kids come home from school and the parent isn't there, or what is going to happen to the children in the event that there's an enforcement action against the survivor. And so in your materials, we do have a caregiver affidavit. And in addition to that, to start thinking about who can take care of your child in the short term, in the long term, what would happen, and make sure the caregiver has the child's insurance card, social security number if they have one. And I think a lot of this and some of the work we're going to be continuing to doing in kind of like the next step of this race is to make sure that we are mindful of creating these power of attorneys of these documents, keeping in mind that some of these issues might be state by state specific, what the information needs to contain, and making sure that they are formed in such a way that does not have any negative impact on a future eligibility for immigration relief. And this link at the bottom talks about making sure your family members can find you if you're detained. And that website that's there is the ICE Detainee Locator, where you can put in information about a person and then you can get up-to-date information about where they are. And now we're going to talk about, I think, safety planning. And so the resources that we have in your safety in the Dropbox can go through that in a little bit more detail, that have samples and ways to kind of layer on that immigration safety planning on top of the safety planning you're already doing for survivors of domestic violence and sexual assault. But the other component of this is the agency safety planning. And so what are you doing internally in your own organizations with regard to issues of ICE enforcement? Are you aware, is everyone in your agency aware of what a ICE warrant looks like versus a judge warrant? You have a policy of what is going to happen if ICE calls? Do you have business cards to clients with your direct number if something happens? And are you aware of your confidentiality obligations? If your agencies receive funding from the Office of Violence Against Women or FIPSA or VOCA, there are other additional layers of confidentiality that might apply to your agency. So it's important to kind of think through how your agency, what concerns folks in your agencies have, and how to kind of build in those plans and those policies and protocols to address those concerns.
Cecilia, can I just add, this is Grace. For those of you who have thought through this or not in the past, I mean, if you're a domestic violence or sexual assault agency, hopefully you already have something like this developed. As many agencies get subpoenas, get requests from law enforcement or child protective services about information for survivors that you're serving, or they may potentially come to your shelter or whatever looking for somebody. And so the concepts are the same as they would be for those state and local agencies, or even anybody else coming to look for somebody you're working with. And so I would commend to you as a resource your local state domestic violence or sexual assault coalitions, or the National Network to End Domestic Violence also has ongoing training that they do around confidentiality. So those are really important resources. But this set of concerns obviously is scary because it's a different entity, but it's the same concepts apply as what you should already be working through in the context of state and local law enforcement.
Great. Thank you, Grace. Mm-hmm. Now we're moving on to Rosie Hidalgo with Casa. Take it away, Rosie.
All right. Thank you very much. And thank you so much to all the participants. It's been a long afternoon with a lot of information, and really appreciate your tremendous advocacy and commitment to these issues. And like Cecilia said, we're going to go about an extra 10 minutes or so because we really want to highlight that in addition to the individual advocacy, your voice is so important in the systems advocacy that we all also need to be engaged in. So if you can go to the next slide. I'm going to just quickly cover a few things. Of course, there are many different aspects of systems advocacy, but there's some key pieces we wanted to highlight as I've listed here. Next slide. So before we get into that, though, I really think a critical pause is necessary here to say, how do we help reframe the narrative from which a lot of these decisions are being made? And so I think you all can play a very critical role in this, and there's three aspects of this that I want to highlight. First of all, how do we address this myth that immigrants perpetrate more crimes, and therefore it is necessary to do these sweeping actions in communities? And as we have talked about, it has a tremendous detrimental impact on individuals, on families, on community policing, on trauma. And so we need to pause. Is this really the situation? And I have in your Dropbox a really good one-pager that the American Immigration Council did. And there also have been some very good recent media stories as well. New York Times did one just a week ago as well, really highlighting that a lot of this is a myth, that in fact immigration is associated with lower crime rates, that between 1990 and 2013, the foreign-born share of the U.S. population did grow from 7.9% to 13.1%. And the unauthorized immigrants also more tripled from 3.5 million to 11.2 million. But during that exact same time period, the FBI data, so we're talking here facts of what shows up in the FBI data, is that violent crime declined 48%, including falling rates of aggravated assault, robbery, rape, murder, and even property crimes. And likewise, when you look at the 2010 American Community Survey, you see that roughly 1.6% of immigrant males ages 18 to 39 are incarcerated, and that compares to 3.3% of native-born males, and that's been consistent for decades. So what I'm saying is here we have to push back on this myth that there's so much crime perpetrated by immigrants. Certainly there are individuals who commit crimes who need to be held accountable, but this other myth leads, I think, to excessive enforcement. And really, as this American Immigration Council document highlights, that we need to keep in mind that immigrants, for the most part, are a self-selected group of people in this country who are really motivated. They've left their homes, they've moved to a new country with the goal of improving their lives and the lives of their children. And so they have great incentive to stay out of trouble. So let's push back on that myth. Secondly, there's a myth that somehow increased enforcement and greater entanglement between local law enforcement and immigration enforcement will make communities safer. Again, I think the DVSA community and those working with survivors can lift up an important voice to talk about how, in fact, this undermines public safety, how it can drive victims and witnesses further into the shadows, making them more vulnerable to exploitation, perpetrators, including sexual violence in the workplace and labor exploitation, tends to grow when people feel that those victims are too afraid to reach out for help or witnesses are too afraid to come forward. So your voice is important to lift up how this undermines public safety. And the third aspect that I think we all really need to elevate is a human rights framework for why access to safety and justice is important for all victims, that this is, there are no second-class individuals of human beings for whom we shouldn't be concerned if they're victims of domestic violence, sexual assault, trafficking, or other such crimes just because of their immigration status. And I think the El Paso case really demonstrated that. To me, that was just such a moment that I think as a field, as a community, we need to pause and really commend the way the judge, the county attorney, and others said every victim has a right to seek safety. And we're about making that happen. Next slide, please. So part of this systems advocacy is also then talking about how do we enhance the collaborations to make this happen, to really ensure that access for all. And again, I want to emphasize that VAWA, since its very passage in 1994, the Violence Against Women Act, included these important provisions that Leslie talked about, the VAWA self-petition, and then subsequently in 2000, the UVs and the TVs were added. And there's really important language, congressional findings that were bipartisan, about why it is important to ensure that victims, regardless of their immigration status, can seek relief, and to recognize that there are extra tools that abusers use based on that person's immigration status. And how do we make sure the system is not sharpening the tools of the abuser? And so our coordinated community response needs to be asking those questions. So you all can be, who are at those tables, with the CCRs, reviewing how are individuals able to access the courts, how is law enforcement sending the kind of message and doing community outreach to make sure that individuals know that they can reach out for help, how are services for victims serving immigrants, all services, not just culturally specific, not just targeted services for victims, but all DVSA services. How are you able to reach out to immigrant communities and let them know that you're there and able to lend support and able to help them do this complex safety planning that Archie so aptly laid out? And offer to provide trainings, the things we've highlighted today. How do we make sure that our courts and law enforcement and others are trained on the VAWA provisions, confidentiality issues, the protections for immigrant survivors? This is a really key moment that you can bring that to the table in those trainings. Secondly, how do we enhance the collaborations with immigrant advocacy between the immigrant advocacy organizations and the DVSA service providers and attorneys? And it's really critical to see how in those partnerships, for example, doing Know Your Rights presentations in the community, that you can partner with them, and leveraging the relationships that the DVSA community has with law enforcement. That's something that if you join forces with immigrant advocacy groups and others in your community who are concerned about what's happening, the relationships that many in the DVSA field have with law enforcement can create opportunities to call a meeting and really sit down with law enforcement and talk about what can be done to make sure that these different rights are protected regarding VAWA confidentiality and regarding just ensuring that people can access these services. And as Grace highlighted, this is going to be very jurisdiction specific. What is happening in your community? Is secure communities going to be implemented? Is it considered a sanctuary jurisdiction? What are the implications? These 287G programs, this is an opportunity, as Grace mentioned, for local law enforcement to enter into MOUs with ICE and be deputized as immigration officials. Jurisdictions don't have to do that. It is an option available to them. But your voice at the table, along with others, and engaging in those conversations with law enforcement can really, hopefully, shed a light on how this can undermine public safety. And we've been there before. This is not new. And I want to remind everyone, and many of you were part of this effort, because we did see an increase between 2008 and 2012, a significant increase with secure communities, with 287G. And it is because the DVSA community lifted up its voice and brought forward cases and demonstrated the detrimental impact that helped give pause and slow down and even change those programs. And in your Dropbox, you're going to see is a link to a report. The Office of the Inspector General and the Government Accountability Office in 2010 did reports demonstrating how the 287G program was flawed, how it led to racial profiling, pretextual arrests, undermined community policing. So these are opportunities for us, again, to lift up what we've learned, to raise our voices, to talk with our jurisdictions. Many major cities' chiefs of police have come forward sharing stories of how this can undermine public safety when victims and witnesses don't come forward. So it's an opportunity to partner with them and try it in your own jurisdiction to convince them not to go forward into an increased entanglement that can harm immigrant survivors and others in the community. Next slide. Another key piece is how do we improve protocols for U visa certification? Like Leslie set forward, more than ever, we need to be helping victims access these critical remedies that are there for them. But we are finding very disparate outcomes in different cities, different jurisdictions. It all depends whether the law enforcement entity in your community has good protocols for how they're going to certify. In fact, recently in Minnesota, they did a FOIA request and showed dramatic differences between St. Paul and Minneapolis. And it was all just a matter of the protocols that were in place. In one city, in Minneapolis, there was a high number of people who could get U visa certifications, better protocols in place. In the other, very low, the number coming forward, extremely low, the number being approved. And then advocates, by seeing these differences, were able to do some advocacy, talk with the law enforcement jurisdiction, do better training, get better protocols in place so that law enforcement understands why Congress put this in place and how important this is both for victims and for the community. So in your Dropbox, you're going to see an excellent Department of Homeland Security U and T visa certification guidance with an excellent frequently asked questions for law enforcement as to why this is so important. And NUOP, Leslie's organization, did an excellent toolkit all on certification that was funded by OVW and BJA. So these are opportunities to really lift that up and look at what your community is doing. Also expanding access to legal assistance. You know, Archie mentioned that people should say, I want to speak to an attorney, but I want to clarify, make sure everyone knows it's not the same as when someone has criminal charges, that you have a right to an attorney if you cannot afford one. Even though immigrants have a right to bring in an attorney, there is no right to one paid, you know, by the state or by the federal government. So more than ever, we need to figure out how do we connect immigrants to legal services, find out what's available in your community, and if necessary, see what kinds of partnerships can expand pro bono attorneys, but making sure they have the right training, the right access to resources to really make sure that immigrant survivors can have an attorney they can contact should they find themselves in that situation. Next slide. Another critical piece of systems advocacy is ensuring language access. As we have talked about, these are complex things, as Grace laid out, that people need to weigh the pros and cons, the risk from the abuser, the risk within the system. And if we're not able to communicate well with a survivor, it really is denying her meaningful access to the services that we need to make sure are accessible to everyone. So again, it's a moment to lift up that all organizations that get any federal funding have an obligation, have a legal obligation in addition to a moral obligation to make sure that there's meaningful access to services for individuals with limited English proficiency. And that's under Title VI of the Civil Rights Act. And you'll see here is a link to a government website, www.lep.gov, that has a lot of excellent resources. And in the Dropbox, I included the recent letter a couple of years ago from the Office of, from the Civil Rights Division of the Department of Justice. It was a letter sent out to all the state courts and administrators of state courts regarding their obligations to make sure there's meaningful language access. Similarly, for law enforcement, the great bulk of whom also get federal funding, they have an obligation to make sure there's meaningful access to the individuals with limited English proficiency. We hear still of stories where law enforcement might turn to a child to be the interpreter, which is completely traumatizing to the child and prevents the survivor from having adequate language access. We hear where the abuser is the one who's the interpreter, or the drinking buddy of the abuser next door who comes over. These things lead to increased dual arrest for immigrant victims when they're not able to communicate properly with law enforcement. And we already heard about what happens when you're arrested. You're much more vulnerable to removal. So more than ever, we need to make sure our own organizations have proactive language access plans in place and do systems advocacy to make sure that these other systems do. And I did provide here a link with the National Latino Network of Casa de Esperanza. We have an LEP toolkit that your organization can use to be able to develop a language access plan and make sure you're prepared to help any immigrant victim that comes, regardless what language she or he speaks. Next slide. This is another critical tool for you to have. And recently, DOJ, HUD, which is Housing and Urban Development, and HHS issued a joint letter in August of 2016 reminding recipients of federal funds that services that meet this three-pronged test here must be made available regardless of immigration status. And the three-pronged test that was established in Perora, so we're talking back in 1996, is that services that are necessary for the protection of life or safety, that are provided in kind and not means tested, meaning not dependent on the income of that individual, are services that should be made available regardless of immigration status. So this includes shelters, transitional housing for up to 2 years, child protection, adult protection services, and many others. So that in your Dropbox, you'll see the letter, you'll see where it lays out the criteria. This is very important because you may, and we've heard this in the past, where shelters will say to us, oh, our board of directors wants us, not to serve undocumented immigrants because they're afraid we might be violating federal law. And you need to push back and say, no, it's the opposite. Under federal law, we're recipients of federal funds. We have an obligation not to turn anyone away because of their immigration status. So use this as a tool. Sometimes at the local level, cities and other jurisdictions, counties have told shelters, we're no longer want you serving those people. Use this as a tool to push back. Next slide. And this is my final slide. That ultimately gathering these stories, as Archie also mentioned, is really critical. We need to really have eyes and ears on the ground monitoring what is the impact of immigration enforcement. And as we saw with the El Paso case, the fact that the judge and the county attorney really, and the head of the DVSA program where that victim was living, I mean, that was just phenomenal. She too spoke out. It really, to me, was just a really great example of community advocacy and commitment. But that story helped raise the awareness that this was an issue, an opportunity to do better, education in our communities, and really highlight why all victims need to access services. So please share your stories so that it can help do the monitoring and the advocacy that we all need to do. And so I'm going to hand it over back to Cecilia to explain how that survey instrument works to gather these stories.
Sure, thank you, Rosie. And so this is a survey that we had set up just to monitor enforcement actions with regards to survivors of domestic violence. It doesn't require any specific information about your client, but we want to hear what's happening. We want to hear how survivors are impacted in your communities. And so please take the moment, if you do have these stories, to share with us, and then we will follow up with you. So we are kind of winding down our time, and we were ambitious in our agenda and optimistic of the time that it would take to go through it all. So we really appreciate your time and your interest in this issue, and we want to just point out a few resources to you apart from the Dropbox that we wanted to share. This is information about how you can get in touch with our organizations, and with regard to NEWAP and their confidentiality website that they're updating as we speak. And then again, some additional resources. IMMI is a really great online resource developed specifically for immigrants themselves to kind of walk through potential eligibility for relief. We have another Google document, which is resources that Assista is collecting on the executive orders in terms of what is going on, some different analyses, and some additional safety planning tools. And these are some other really amazing resources that we want to make sure that you go through with regard to additional information that you will be able to find. We are also repeating this webinar in Spanish next week. What day is that, Rosie?
It's going to be next Friday, March 3rd at 2 p.m. Eastern Time.
Okay, so we will make sure that we send that information out as well. Thank you again for your time and for your support of this issue. I want to thank my amazing co-presenters for sharing all of this great information. And again, this is just the beginning of the conversation, and we hope we'll stay connected with you as this issue moves forward. Thank you and have a great day.
Thank you, everybody.